We are glad to have many esteemed attendees with us today for our webinar on project management in contractual and legal aspects from the perspective of main contractor. My name is Lee Ping Yi, pupil in Chambers of Hong and Kuwait, and I'll be the moderator for today's session. Before we kickstart this session, please be informed that all participants will be muted, and if there are any questions, please type in the Q&A chat box and we will discuss them during the Q&A session later. Now, please scan the QR code appear on your screen for attendance purpose. Please allow me to introduce our speaker, Mr. Ankit Sanghvi. Mr. Ankit's focus area of practice is in construction law, and he has handled significant assignments involving energy projects, engineering projects, and infrastructure projects for both local and foreign clients. Ankit's legal experience has enabled him to provide professional legal advice to his client in respect of building and construction projects in Malaysia from its inception right up to its completion. Ankit has conducted documents review for clients, provided advice, and drafted agreements for employers, developers, contractors, subcontractors, vendors, purchasers, and tenants on various aspects of commercial, retail, and residential construction projects in Malaysia. So please join me to welcome our speaker, Mr. Ankit Sanghvi.
Thank you, Pinyi, for that very nice introduction. And without further ado, I welcome all participants. Welcome all participants for today's talk. And I will start with the slides. So the title for today's session, as you would see on your screen, is Project Management in the Construction Industry. The session is expected to last for about an hour and a half, and the topics that I will cover in this session would include management in the construction industry by the three main stakeholders, which would be the contractor, the developer, which is the landowner in most cases, and of course the project administrator in situations where there are architects or engineers. So we will start, I think first and foremost, we need to ascertain the key legislation in the construction industry, because whether you are the contractor or whether you are the landowner developer, both parties ultimately need to be aware of the key legislations in the construction industry. And this key legislation can actually be seen on your screen right now. They are essentially the Town and Country Planning Act 1976, the Street Drainage and Building Act 1974, and the Uniform Building Bylaws 1984. So these three legislations that you see on your screen provides the minimum standards for the control and construction of street drainage and building in Malaysia. It also sets out procedures regulating the application for, amongst others, of course, building plan approvals, which is very important in the project management aspect of construction. And it also has requirements for firefighting services, which goes down to health and safety issues. Now, other applicable legislation, I would classify them into key legislation and other ancillary legislation. So what you see on your screen right now, what we call other ancillary legislations which support the main legislations, and they are the Federal Roads Act, the Quantity Surveyors Act, Registration of Engineers Act, Architects Act, the Malaysian Highway Authority Act, the CIDB Act, the Federal Roads Act, Road Transport Act, and the Town Planners Act 1995. So all of these legislations are key and instrumental in the construction industry. And usually, as I've mentioned, whichever side you are on, you would need to familiarize yourself with these legislations, because in project management, all of this will somehow at some point become relevant, whether when you're engaging your surveyor or engineer or the architect even, these are the legislations that would be applicable. And finally, of course, you have the Construction Industry Payment and Adjudication Act, which is a specific legislation introduced in 2012, which is in relation to payment within the construction industry to ensure that there is continuous payments, and it's a process which allows for adjudication of a dispute, and it's a rather fast and quick process compared to the normal process of going to court, for example, or going through a full arbitration. So you would please note that there are separate legislative requirements for projects in East Malaysia, Sabah and Sarawak, and the Federal Territories. So what you see on your screen is, of course, applicable to West Malaysia. Now, so what are some of the specific requirements that parties should be aware of? uh, I have divided it into 5 different parts. So again, this goes for both the contractor and the landowner. These are the 5 areas which I will deal with, each one by one, in the next slide and thereafter. The first requirement in regards to health and safety, we will most likely have a full session on this later on in the month of August. But what is health and safety, and who is actually in charge of health and safety in Malaysia? So it is the Department of Occupational Safety and Health, which is responsible for enforcing 3 pieces of legislations. And this is the Occupational Safety and Health Act 1994, the Factories and Machineries Act 2006, and the Petroleum Safety Measures Act 1984. And as you can see, the Occupational Safety and Health Act 1994, its main purposes is to secure the safety, health, and welfare of persons at work, and to protect other people against risks to safety or health in connection to the activities of the persons who are conducting the work, which is usually the contractor. It could also be the landowner who may be conducting certain types of work, but ultimately it is to regulate the safety and health aspects of persons at work. And it's to promote, of course, occupational environment for persons at work to adapt to their psychological needs, physiological and psychological needs. Sorry. The FAMA, which is Factories and Machinery Act 2006, is to ensure the fitness of machineries deployed during the course of construction. As we would all agree, machines are an essential tool in the construction industry, and therefore it is very properly regulated under the Factories and Machineries Act. And there are certain machines which you need approvals from the Factories and Machineries Act before you can actually use them. So it is a very important act in the aspect of health and safety in the country. Finally, you have the Petroleum Safety Measures Act 1984, and this is perhaps not relevant to every project, but it is relevant to some. So I've put it on here, and it is essentially to safeguard the safety in transportation, storage, and utilization of petroleum, to provide for matters relating thereto. As we know, some constructions may involve uh, transport of petroleum, and in such cases, this is the legislation that you would need to be aware of when we speak of project management as a whole. Now, the next area is in respect of environmental. We have gone through health and safety. Now, what are the specific requirements that parties should be aware of in respect of environmental laws? So the Department of Environment in Malaysia is entrusted with ensuring a clean, healthy, and safe environment. And the specific act that we would need to be aware about is the Environmental Quality Act 1974. Now, it not only regulates air environment in terms of the air, but it also regulates noise, sea, and land pollution. So it is really a full act which covers the entire all environmental issues. And if the proposed project falls within the list of prescribed activities, okay, prescribed activities, I put it in inverted commas because it is the word used in the act itself, then what needs to happen is an environmental impact assessment, or what we call an EIA, must be carried out as part of the approval process. So again, when we speak of project management, the Environmental Quality Act is something that is quite crucial because in certain situations, your proposed project may fall within the list of prescribed activities. And in such a case, you need to be looking at the Environmental Quality Act 1974. Now, when it comes to planning, there's of course requirements that all parties should be aware of. So because planning is a state matter and it does not fall within the federal jurisdiction, of course, except for the federal territories itself, you would have to see how the state laws are in the respective state where the project is being carried out. Now, the approval process is quite standardized and it does not differ too much between the different municipal authorities between each state or district. But the approval process briefly involves the following stages. The first thing when we talk about planning is land use conversion. So there are three categories of land use in Malaysia, which is building, industry, and agriculture, the three main ones. And dependent on the nature of the project, it may be necessary to apply for a conversion of the land use prior to the project implementation. I'm sure all of you who are involved in project management must be very familiar with this area because this is something that I believe Country Garden themselves have actually had to do on various occasions. So when we again talk about project management, these are the things that you want to be aware of because land use conversion is something that almost always has to happen in large projects at some point. So planning permission or development order approval stage. So any project categorized as a development within the meaning of the Town and Country Planning Act requires prior planning permission from the local planning authority. This includes any material change in use of the land. The DO, which is the development order, may be granted with certain conditions imposed. So again, this is another very important area of project management, the development order. The process of getting the development order and seeking for the development order during the approval stages. Finally, we have the building plan approval stage, which is building plans must be submitted by a qualified person as defined under the Street Drainage and Building Act. So it's not just, you can't do it on your own. You need someone who is actually qualified under the Act to be the person who submits it for you. When it comes to employment, these are the 4 acts that you see on the screen that you should be aware of. There's the Employment Act 1955, which is the main primary legislation, the Children and Young Persons Act 1966, the Employee Restriction Act 1968, and the Workmen's Compensation Act 1952. Now, each one of its key take-home points are listed on your screen. For example, the Employment Act 1955, it protects employees earning less than 2,000 per month or employed for manual work. So this is a minimum wage sort of protection. And Children and Young Persons Act, it prevents exploitation of child labor by limiting working hours and nature of work as a child. Employment Restrictions Act, it requires foreign labor working in Malaysia to hold a valid permit. So when you're hiring foreign employers, whether from China or any other part of the world, you need to look at the Employment Restriction Act 1968 because there may be certain restrictions against certain types of foreign laborers. Workmen's Compensation Act, which is safeguard the rights of foreign workers who encounter accidents at work or contract employment related diseases. So this is of course quite similar. You've heard of SOCSO. So this is what the Workmen's Compensation Act 1952 deals with. Finally, you have the Anti-Corruption and Bribery Act, which is the Malaysian Anti-Corruption Commission Act in 2009. Now, all of this that you see on your screen, the Penal Code, the Customs Act, and the Anti-Money Laundering and Anti-Terrorism Financing Act are all acts that deal with corruption and bribery or any other criminal sort of implications that a company, be it the contractor or landowner, could potentially get themselves into. So under the MACC Act, for example, both the party who receives and gives any bribe as an inducement for anything, for any activity is considered illegal. And most recently, as most of you would know, there is already the inclusion of Section 17A, which only hit its first year anniversary in June this year. And so far, there's only been one case where Section 17A has been used, but ultimately Section 17A speaks of corporate liability, which means that even companies can be charged under the Malaysian Anti-Corruption Commission Act. Previously, it was only for individuals. So this is all now very relevant for all corporations in the industry of construction. Now, Project management will not be complete without obtaining permits and licenses. So during the works, it may become necessary to apply for other form of permits and licenses, but I will take you through the Construction Industry Development Board Act, which is the 1994 Act. And this act, for example, sets out a list of construction materials that must first be certified by CIDB prior to them being used for any construction works. And if you fail to do so, failing to obtain the such certification, it could lead you punished up for a fine of up to 500,000 ringgit. And the need to apply to the local authorities if construction works are to be carried out beyond the allowable construction working hours. All of this would require special permits and licenses. Now, what happens once the works are completed? Again, there is some sort of a document which we all know needs to be issued. So what is the document? Upon completion of the works, a principal submitting person, or what we more commonly call the PSP, who must be a professional architect or engineer with a valid practicing certificate, and he must sign a certificate called the CCC, which is the Certificate of Completion and Compliance. And this is to confirm that the project completion and that all statutory requirements with regards to health and safety aspects have been met. And the project is ready for occupation with all essential utilities services connected. Yeah, when we talk about essential services, we talk about electricity and water. And false certification by the architect or engineer could lead to a fine not exceeding 250,000 ringgit or to imprisonment for a term not exceeding 10 years or to both. So the principal submitting person, who's again quite an important person in the entire project, has to ensure that the certification is done fairly. And because the CCC is a very important document that actually boils down to health and safety and occupational requirement. So it's basically saying the house is now fit for usage. So it must be certified properly, and failure to do so could lead to fine or imprisonment for the certifier, which is the PSP. Now, who are the parties involved in a construction project? We know that the number and types of parties involved will ultimately depend on the nature and complexity of the project. The more complex the project, the more likely we have more parties involved. Traditionally, back in the day, the design phase is separated from the construction phase. So there will be a designer who designs the entire project that is intended to proceed, and there will be the builder, who is the contractor, who will proceed on the construction based on the design of the designer. So now during the design phase, the owner, who's also known as the employer, would hire a design team consisting of architects, quantity surveyors, and civil engineers to determine a workable design for the project. Once that is completed, the construction phase is then engaged when the owner hires a main contractor to construct the project. And this is when everything essentially starts, or the relationship technically starts between employer and the contractor. Now, it is common for the project works to be divided into subcontract packages. This is all something that we should all be familiar with, because subcontract packages is something that Country Garden does very often. So what happens is then they are subcontracted to various specialist subcontractors. Separately, or alternatively to that, the owner may prefer a single point of responsibility by appointing a main contractor who would be responsible for both the design and construction of the project. So as you can see, you see the distinguishing factor here is in the traditional method, design is separated from the construction, but this is what we call a single point of responsibility, where everything falls or lies on the contractor. The design and the construction of the project is the liability and duty of the contractor. So this is what we call a design and build model. And technical and design consultants may also be directly engaged by the owner as and when required to provide their expertise in the project. Now, we have touched on that. So what are the common procurement methods in Malaysia? I've already discussed two of them, but let me elaborate a little bit more on it. So the traditional method, which is the construct-only method, the main contractor is engaged only for construction phase, and the owner is fully liable for the design of the project. So if there's an error in the design, then this is something that you will not be able to blame the contractor for proceeding with the project. This for a long time was the preferred option for the bulk of government contracts in Malaysia and private sector projects in Malaysia. But recently we have seen is an evolution from the traditional method moving to the package deal method. And this is used more commonly for large scale complex projects, are often tendered on a package deal basis under which the main contractor assumes liability for both design and the construction of the project. So this includes design and build, turnkey contracts, and even EPC contracts. Now, what is the main attraction of this? So the main attraction is the procedure which involves a single point of responsibility. For example, in Malaysia, one successful project that we can talk about is the employment of project delivery partner, or something known as PDP. It's a structure that was created in the construction of the Klang Valley Mass Rapid Transit, which is the Klang Valley MRT project, the trains that you see out in Kuala Lumpur. So the PDP plays a similar role to a project manager, but with the added responsibility of having to deliver the project within an agreed time period and cost. So the PDP, as you can see, is a person who is just named the project delivery partner, but he plays the role of everything. He plays the project manager's role, but he's in charge of everything, and he will ultimately deliver the project is required to deliver the project within the agreed time period and cost. Of course, this kind of methods are a lot more expensive because all the risk is on the PDP. Therefore, you can expect that they would charge a lot higher when it comes to the pricing of their fees. What about procurement through design and build? So normally a contractor is selected in competition to execute a project under the design and build option. This is of course done through a tender process, and tenders are invited on the basis of employer requirements. On the basis of employer requirements, a document prepared, which is a document prepared by the employer in consultation with his design team. You would all be familiar with the term employer's requirements because it's something that may come about in some of the contracts. But what is the employer requirements? It essentially sets out the project needs in terms of specification, function, and performance of the building required. And if applicable, it will also define the planning and any other restrictions that may exist. The contractor, what does he do? He responds with a set of contractor's proposals upon which the tender bids are assessed. Assuming the contractor's proposals fulfills the employer's requirements, the lowest bid is often accepted. But this is not the case all the time because sometimes there may be other considerations which you may want to look into. For example, maybe the aesthetic value of another contractor. So ultimately, the considerations are various, and you do not need to pick the lowest bidder, but this is the process which involves first the employer stating his requirements and the contractor then responding with a set of his proposals. So in many cases, and particularly where a project is of complex nature or facing difficult planning procedures, the employer often appoints a design team to negotiate planning, to prepare the preliminary designs and specifications, and a detailed design brief which is incorporated into the employer's requirements. And they do this before seeking design and build proposals from the contractors. Obviously, this is something very common that happens because the employer often enough doesn't know much about what needs to be done. So you would engage a specialist who would basically do up your requirements for you. You then hand it over to the contractor to seek for the contractor's proposals in respect of your requirements. So the employers often refer to this process as develop, then design and build. So the develop part is when they are developing it at their end, and design and build is when they just transfer everything out to the contractor. And contractors refer to it as design and dump. So these are just terminology used in the industry. This development of the design ensures the client gets a design that works for him, and the risk of the final design and construction works is assumed by the contractor. So this is very good for the employer because all risks lie with the contractor, although the employer had some say when it came to the design due to the employer's requirements. So in some instances, and where the employer agrees or requires it, the initial design team can be novated to the contractor. And once appointed, the contractor either commences the work with his own design team, or where it is specified in the tender, he will then employ the employer's design team through novation agreements. I can't touch the issue of novation agreements because it needs to be dealt with together with assignments and novation, which is a very large topic. It doesn't deal much with project management, so I will perhaps deal with that at another time. But ultimately, the employer normally retains his quantity surveyor to act as his representative. And this person is assumed to be a non-technical member and could be the only named party apart from the contractor. And as there is no quantity surveyor included in the contract form, it is therefore logical for the employer to retain his QS to protect his interests and to act as his representative. So as you can see here, this is the procurement method through the design and build. It speaks of the process that is involved. And now let's look at the type of forms and how they apply in Malaysia. So currently in Malaysia, apart from the FIDIC standard forms and the PWD-DB standard form, there are no other proper design and build standard form of contracts for the domestic Malaysian construction market. So this standard form is, of course, for, as you know, the PWD is for government projects, but it has been amended for use by private clients as well. Under the PWD contract, there is no requirement for novation of the design team, and which is employed under the contractor itself. So the PWD form of contract, or the FIDIC yellow book, is suitable where the employer requires a firm lump sum requirement, and where the required standards and quality can be easily defined in the ER, which is the employer requirements, before seeking for tenders. So for more control over quality and cost, this procurement route can be used in a develop, then design and build form, where a private employer's design team initially negotiates and obtains planning permission, prepares outline designs, specifications, and a detailed brief for the employer's requirements, particularly where more complex buildings are required under this procurement method. In some instances, the employer's design team is required to be novated to the contractor after award of the contract. Well, and now what are the advantages and disadvantages of design and build? The advantages, as I have already discussed, first and foremost, it provides single point of responsibility. Secondly, it's a fixed lump sum price, which has been established at the onset, and it is only subject to changes which are made by the employer. Variations are usually agreed upon, and the employer has the opportunity to instruct, or otherwise he knows the full consequences in terms of cost and time. The contractor is responsible for organizing and programming the design team's activities. So the employer is therefore not responsible for EOT in the event that design information is not produced on time or similar events. Generally, the risk for unforeseen circumstances are the responsibility of the contractor. What are the disadvantages? It provides the client with arguably a less sophisticated building in terms of design detailing than would be the case with other forms of procurement. Obviously, because you do not have an expert who's actually doing the design. It gives less control over the work in total and of the cost of any variations required. It can be difficult in certain instances to precisely define the standards and quality of design required. And finally, a higher contract value than would otherwise be the case results as a result of the risks imposed on the contractor. So that goes without saying, if all the risk is on the contractor, it would be reflected in the price that you are paying. So ultimately, whether you go for the traditional method of design and build, the traditional method, or you go for the design and build method, they both have their own respective advantages and disadvantages. So you would ultimately have to choose your procurement method depending on the type of project that is being initiated. Now, the standard forms of contract in Malaysia, there are actually three main contracts, which is the Public Works Department contracts. This is used for government projects or state government projects or even GLCs. The most popular one, I would say, is the Malaysian Institute of Architects contract, which is the Persatuan Architect Malaysia, and is most commonly used for private building works. There's the IEM contract, and this is used for engineering projects. And we also have the FIDIC Yellow Book for plant and design build. And it's quite popular for private projects involving large scale or infrastructure or international parties, where parties would often vary many of the terms in the particular the FIDIC agreement itself, just to cater for their special individual needs of the project. Other types of contract are private contracts. So you can see, like, for example, Petronas, TNB, they all have their own respective in-house suites of bespoke contracts. So these are contracts that they use with their vendors. And hopefully someday we may see a Country Garden contract as well. Now, letters of intent. So letters of intent is what starts the entire process when the employer tries to link up with the contractor. So it is fairly common practice that parties to construction contracts initially use letters of intent. And the reasons for this practice are for three reasons mainly. The construction contracts can be very complex and detailed documents, and thus in many cases, a letter of intent can mitigate any delays which would result in commencing the works while the parties prepared and agreed the content of any proposed contract. Secondly, the developers or end users of a property or facility are sometimes under pressure to start works and complete the projects for such reasons such as financing, to meet obligations to third parties, or simply because the project is required to be put into operation as quickly as possible. The contractor may similarly be desirous to obtain a letter of intent to confirm the project and end speculation and risk of not being awarded the project. So simply put, this entire process of a letter of intent is basically sort of a step before you enter into the formal contract. But it's very important because it ultimately already sets out the parameters between the respective parties, and it speaks more often than not of your intention to formalize and enter into a contract at a later date. But there are a lot of issues that come with the letters of intent. Firstly, we need the most common ones are firstly whether to establish whether there is indeed a contract that has been formed by the letter of intent. And if if there has been a contract that has been formed, then what is the basis that you are saying that? Establishing if an ancillary contract has been formed to perform the works, and whether this ancillary contract exists while awaiting the execution of a formal contract for the substantive part of the works. So is there an ancillary contract that is in existence is something that we need to think about. And finally, establishing what, if any, are the contractor's rights where the developer or the owner abandons or cancels the project before any form of contract is executed. So this is where a letter of intent has been given and signed, all done. And finally, for some reason down the road, the employer doesn't want to engage the contractor. What are the rights of the contractor? What are the rights of the employer? So this is where we will look at a few cases. But to establish if a contract has been formed, it is essential to show that there was an offer and there was an acceptance of that offer. So words alone are not enough to be the sole consideration to determine the intention of the parties. The court will always look into the intents and the actions of the parties in their dealings with each other. So all your correspondences are very important. That is why I say when it comes to project management, whether you are the contractor or whether you are the employer, both parties need to ensure that document keeping and so on are all very much in order, because when there are disputes, it would really go on. For example, a dispute in relation to letters of intent, it would ultimately be, the turning point would be, how did parties communicate during the entire period? Was there sort of a confirmation that they would sign the agreement or not? Or was it just merely speculation? So this is something subjective and it would be dealt with on a case-to-case basis. So this is just an example of a case, British Steel Corporation against Cleveland Bridge, a very popular case of 1984, used in Malaysia as well. And in this case, the owner, in a letter of intent to the contractor, advised him of their intention to enter into a supply contract and proposed a number of terms and conditions which were never at any stage agreed to by the contractor. The parties exchanged correspondence to each other, asserting their respective preferred terms, but they never achieved any agreement. The contractor eventually completed the works, but the owner insisted that the contractor was liable for liquidated damages due to the delay in the delivery of goods. And what is important here is the delivery schedule itself was in fact one of the terms which parties could not agree upon. So what did the court find in this case? You would see down there in italics here, the judge stated there can be no hard and fast answer to the question whether a letter of intent will give rise to a binding agreement. Everything must depend on the circumstances of the particular case. So as you can already discussed earlier, a common area of dispute occurs is when a contractor starts work on the strength of a letter of intent and the owner decides not to proceed with the project. So that presents the contractor with two major problems. First, how is he going to get paid for the works which he has performed? Because technically he has performed the works before entering into the contract. Is he entitled to claim for such works? The answer is yes, he will be able to, on the basis, it will be depending on the basis of the contents of the letter of intent, but alternatively, he could be offered or he could be compensated on a quantum merit basis. In the event it has been decided that there is no contract formed, you can still be remunerated or compensated on a quantum merit basis. What does that mean? It means you'll be compensated according to how much work you have done during that period. And finally, the other problem is establishing whether he has a remedy against the owner for breach of contract, whether he can sue the owner for other things. For example, loss of income. Maybe you have hired 150 employees for this particular project, and now they have terminated or they don't want to sign the main contract with you. So those are all things that the contractor may be possibly able to claim for breach of contract by the owner if he has done so without proper basis. Now, Turif Construction against Regalia Knitting Mills, 1971 case, but still very relevant in the country. The contractor requested a letter of intent to cover it for design work under a proposed design and construction project. Cover it simply, in my understanding, just means to include everything. Yeah. So the employer, through a letter signed by one of its directors, wrote to the contractor as follows: as agreed at our meeting, it is the intention of Regalia to award a contract to Turif to build a factory. All this to be subject to obtaining agreement on the land, and the whole works to be subject to agreement on an acceptable contract. Now, shortly after the project was cancelled by the owner denied any liability to the contractor, and in respect of expenses the contractor had incurred in executing the design works to that date. So what did the court find? The judge found that a letter of intent will ordinarily have two characteristics. One, it will express an intention to enter into a contract in the future. And two, it will itself create no liability in regard to that future contract. So the contractor failed in their claim for payment of design costs under quantum merit as a result of the express agreement as to payment for interim work in the letter of intent. So bear in mind that this was already covered for in the agreement. The court held that parties had turned their minds when the contractor requested the letter of intent. This, together with the inclusion of the words subject to in the letter of intent, had shown that parties had failed to form a substantive contract. So what I want to say here is it doesn't mean that every time you use the word subject to, you are going to be, or the employer is safe in the sense that he doesn't need to enter into the formal contract. It will still be looked at in the full circumstances of the facts. So the word subject to does not in any way necessarily mean that there is no contract or there's no intention to enter. It will have to be looked at the full with the full facts of the case. So an ancillary contract for the design works as a result of the pre-contract discussions and the letter of intent was held to exist in this case. So from this judgment, it is commonly accepted that contractors who execute works under a letter of intent will usually be able to obtain payment for works executed on the basis of the letter, either under the doctrine of quantum merit, which I've explained is basically getting paid for what you have done according to normal market value, and where it is held that there is no contract was formed, or where it is held where an ancillary contract is in place on the basis of that formal main contract to be entered into later. Now, this is a very short part. Engaging consultants. So, of course, we have, I would say, three main types of consultants. And it's the decision to engage a consultant is still very much, of course, depends on the nature and complexity of the project. But ultimately, we have engineers, which can be divided into mechanical, electrical, chemical, and geotechnical engineers. We have interior designers for housing development projects. We have environmental consultants for projects that have likely to have a significant impact on the environment. So these are people that the employer usually engages, and sometimes even the contractor engages, depending on the procurement method that is used. But project management involves not just managing your team, but it also involves managing your consultants, for example. So you will enter into agreements with them. And to do so, you need to, of course, be familiar with other types of contracts, because you have different types of contracts for the appointment of different types of consultants. For example, architects are required to adopt the standard conditions of engagement, including the minimum scale of fees as prescribed under the Architects Act 1967 and its subsidiary legislation. So you can't just simply pay an architect as per whatever you feel like. There is a particular way in which architects are to be paid, and all of this is to be entered into in the formal contract, which would be governed by the Architects Act 1967. The Board of Engineers in Malaysia similarly provides a standard form for the appointment of consultants. Now, security. Security is, of course, a key element in any construction project, because an employer or a landowner would not want to proceed with the appointment of a contractor if he or she does not give a proper form of security. So what are the forms of types of security that you need to be familiar with when it comes to managing projects? There are three types of, or actually there are four, but what you see on your screen, there are three types of common security methods. First is on-demand bonds, which is where the owner often stipulates in the contract that the contractor must provide on-demand performance bonds to guarantee the due performance of the contract. These bonds entitle the owners to call on the bond without the need to first establish a default on the underlying contract. So you can see it is extremely, extremely powerful. And this is something we see very often in Malaysia. So it's fair actually to say that employers do have somewhat of an upper hand when it comes to security, because they're allowed to call on the bonds without even first the requirement to establish a default if it is in the nature of an on-demand bond. So these bonds may then be used to compensate the owners or employers when the contractor defaults or if there is a delay in the performance of the contract. Parent company guarantees, which is usually where a special purpose vehicle has been formed solely for a specific project. Usually companies entering into contracts with those type of SPVs wouldn't be satisfied with a bond given by the SPV itself. You want the parent company to give the bond. So this form of security provides owners with the comfort that the parent company is willing to undertake any default of the SPV. Obviously, you want the security coming from the richer party, the party who is more financially viable. So managing a project involves all of this, because you do not want to have you do not want a security which you are not going to be able to actually recover. It's just going to be a security on paper without really much ability to obtain it. Next, we have advance payment bonds. So advance payment bonds are applicable in circumstances where a contractor applies for an advance payment from the owners to help with mobilization and procuring materials. So typically, the advance payment will be repaid through the deduction of a predetermined amount from each progress payment of the project. The advance payment bond will then be cancelled upon full repayment. This is, I would say, not very commonly used, but it is something that parties try and enter into negotiations with the contractor, because it sort of gives the contractor more room to deal with his payment bonds, because it is deducted from uh, each invoice that comes thereafter. So it is not delivered at the beginning of the contract. Now, the norm is for such securities to be tied to cover the entire project phase. So what does entire mean? Will depend on the provisions within the contract, but some contracts may stipulate that a bond shall be valid and enforceable until practical completion of the project. Some other contracts may actually say that it may extend that period till the end of the applicable defects liability period. Now, it is also common for contracts to impose an obligation of procuring separate bonds covering different stages of the contract. This is again something that can be done, a bit more complex, but it is something that you may want to actually consider, especially for very, very large construction projects. So unaccounted delays may result in the lapse and expiry of these securities. Therefore, it will be prudent for contracting parties to insert provisions imposing an active renewal obligation to ensure the validity of the securities. This is very important, ladies and gentlemen, because when we talk about bonds or security in the form of bonds, all of them actually have a lapse or an expiry date. So you need to absolutely be certain that as the expiry date is coming closer, you get the whole bond renewed. Because if the bond expires and then there is a breach of the contract, the employer is probably not going to be able to call on the bond because the bond has technically expired. So dates are very, very important when we speak of project management. Retention sum, another form of security. This is the fourth type of form of security, which are monies deducted from progress claims to protect the owner employer in the event a contractor fails or defaults in its performance of the contract. So this is much like the advance payment bond, but apart from the PWD form 203A, most standard forms of contract in Malaysia do have clauses which deal with retention sums. And in fact, if your clause or if your agreement doesn't contain a provision for retention sum, the courts have actually held that in the absence of a contract to the contrary, an owner should maintain retention sums in a separate account on trust for the contractor. So this is the law as it stands today. So you have to do so as the owner. Every time there is a progress claim, there's a certain amount of it that will be held as a retention sum. So can parties exclude or limit liability? It's something that we always try and do, obviously, but what does the contract actually say? So it is not unusual, yeah, to find a limitation of liability clauses in construction contracts. You would see, for example, under clause 17.6 of the FIDIC Yellow Book, there is a type of a limitation of liability clause. And in Malaysia, the courts will uphold the clauses that you have actually decided to be bound by, and they would very rarely interfere into the contractual interpretation of your clauses. They are strictly accepted by the courts, and they will only try and interpret the clause if it's unclear or there is some sort of uh, lack of clarity in the clause. Then the court has to interpret it. But otherwise, if you have a limitation of liability clause in your agreement and it is worded very clearly, very expressly, and easy to interpret, then the court or the judge hearing the matter has to actually respect that particular limitation of liability clause. But for example, if you look at my last point, nonetheless, if these clauses are so wide as to raise the prospect of an absurdity that would defeat the purpose or main object of the contract, for example, excluding liability for a fundamental breach of the contract, then such a clause may not be upheld by the courts. So you can see that the court would, in very rare situations, if it's very blatantly unfair or it creates an absurdity in the entire, doesn't makes the contract almost insensible, then the court may actually come in and intervene to try and interpret it in a fair way for the parties. Termination is a very important thing for both parties, the contractor or the employer, because both sides may need to terminate the contract at some point. But as a general rule, the right to terminate a contract arises not contractually, but it actually arises from law, from our statute itself, which is the Contracts Act 1950 in Malaysia, in particular Section 40. When we talk of contracts, the standard form of construction contracts adopted in Malaysia will almost always include termination clauses. For example, clause 51 to 55 of the PWD Form 203A, in clauses 60 to 64 of PWD Form DB. And in other contracts, they are known as determination clauses and other types of contracts. And these can be seen in clauses 25 and 26 of PAM contract and clause 44 of the JKR Sarawak form of contract, which is used in East Malaysia. Now, failure to strictly comply with the termination procedures set out in the contract could render the termination invalid and or wrongful. This has been decided in the case of Fajar Menyensing against Angsana. In essence, what I want to highlight here is the process of termination. You may have a very, very good cause to terminate the contract, but if you do not comply properly with the termination procedures under the contract, the notice provisions under the contract, then it would possibly be dealt or could possibly be considered as an unintended repudiatory breach of the contract. And this means that technically you have unfairly or you have without basis terminated the contract. Although you may have a proper cause of action in law, but because you have failed to comply with the relevant procedures, notice procedures, and so on, the termination is deemed to be invalid and you could be considered to be the party who has breached the contract and for wrongly terminating the contract. So it's a very important step or termination and of course compliance with the relevant provisions under your termination provision. Force majeure clauses are something that we see in contracts as well. There is no common law doctrine of force majeure in Malaysia. However, you do see force majeure clauses in some of the contracts. For example, under clause 57 of PWD Form 203A and clause 19 of the FIDIC Yellow Book. But ultimately, force majeure means that if either party considers a force majeure event to be of such severity or it's to be continuing for such period of time that it effectively frustrates the original intention of the contract, then parties may agree to a mutual termination. Now, notice of claim for additional time and money. Yeah, so time and money is, of course, the two key things that the contractor would want to claim for. Sometimes he needs more time to complete the project. He would need an extension of time. Sometimes he needs money to complete the project because the delays caused are actually attributed to the landowner. So these are all covered under the contract, and typically there are very strict provisions which also require proper compliance with the procedural requirements for EOT or for claim for money. So you must again comply with the notice provisions very, very strictly. In the case of Ipoh Tower against Taki Engineering, a couple of years ago, the High Court discharged the employer from any liability for claims made which did not comply with the notice requirements set out in the contract. So as you can see, the court will not even bother to see whether there's actually a basis for the EOT or basis for the money. They will just simply look at the fact that there's been non-compliance of notice requirements, and therefore there is no need to consider anything any further. So when you talk of managing contracts, the contractor has to be very careful about this, and he has to ensure that it's all done in a timely manner and in strict compliance with whatever procedures that are stated in the agreement. Now, insurance. This would depend on the agreement between parties and the standard form of contracts. But under the PAM contract, you have clauses 19 and 20, which deal with insurances. And the contractor is obliged to take out and maintain, amongst others, insurance against injury to person and loss or damage of property arising out of or in the course of the execution of the works. And secondly, insurance for local workmen who are not subject to registration under SOCSO, which is the Employee Social Security Scheme. So both of these types of insurances are usually borne by the contractor. Parties could also agree, this is subject to, of course, both parties agree, to either impose an obligation on the contractor or the employer to take out and maintain, in the joint name of the contractor and employer or subcontractor, or any other all interested parties for that matter, a CAR insurance policy, which is what we call a contractor's all risk insurance policy for a value not less than the contract sum. And it's, of course, to cover against losses or damages by anything which include fire, lighting, explosions, storms, and so on. These insurances are typically required to cover the entire duration until the completion of the works and up to an extended period of 3 months after the defects liability period under the contract. So that is more relevant for the contractor when we talk of insurance. Limitation period. How long do you have before you can actually file a claim against the party you want to sue? So the general rule is that you can bring an action in relation to any breach of contract or tort 6 years from the date the cause of action came into fruition, or since from the date when the cause of action accrued. This is provided for under Section 6, subsection 1 of the Limitation Act. So when exactly does the cause of action, when does the cause of action accrue, is often subject to the dispute between the parties. And there are conflicting judicial decisions on this. You have the two Mbang cases on your screen. The first case against Mbang and Abdul Aziz bin Hassan said that the cause of action accrues regardless of whether one discovers the damage or not. So you may have discovered it later, 2 years after it, but the time starts to run when the cause of action actually accrued, even though you may not be aware of the particular thing. Separately, Mbang against Kamaria Hamdan, 3 years later, said cause of action only accrues upon knowledge of the damage. So you can see we have inconsistency here when it comes to the courts interpreting the issue of accrual. So Limitation Act 1953 was amended to introduce a provision with regards specially to latent defects. So under this new provision, if a defect is discovered outside of the limitation period, this is very common because most of the time, latent defects are discovered beyond 6 years. So if you discover such a defect 6 years from the date of 6 years after the defect has occurred, then parties have 3 years from that date of knowledge of such a defect to commence a claim. So a defect may have occurred today, but I may have only discovered it 7 years from today. Then I am still allowed to initiate a claim, provided I bring my claim within 3 years from the time I discovered the latent defect in the 7th year, for example. But notwithstanding that, any claim under this provision is subject to a maximum time bar of 15 years. So once 15 years have passed, then there's an absolute no claim for latent defects that can be brought by any purchaser. Now, in respect of claims against a government agency or a public servant, the imposed limitation period is 3 years starting from the accrued date of the cause of action. So that is for government projects. And that brings an end to the session. So I will leave it with the MC, and of course, feel free to ask any questions that you may have before we move on to the next slide, which is the sorry, yeah, this is the Q&A QR code that you would need to scan for the question and answers. So
Uh,
thank you very
Thank you,
much.
Mr. Ankit. Thank you, Mr. Ankit, for the enlightening sharing. I'm sure that is very helpful to many, especially to our attendees today. So now we have come to the Q&A session for this webinar. You may post your question in the Q&A chat box if you have any questions. So for now, we have one question from Mohammed Azman. This question is regarding to construction disputes. So the first question is it all the disputes between parties involved in construction must brought to civil courts, or are there any other ways to resolve the issue?
Yes, thank you, Azman, for the question. There are actually many ways to resolve a dispute. You do not need to always bring it to the civil courts. Your contract under the PAM contract, for example, more often than not has a dispute resolution clause, which will in fact say the reverse. It says that any dispute must be subject to arbitration, for example. So in such a case, you won't go to the court, but you have to be confined by arbitration, which is the method to resolve your dispute. You also have adjudication, which is now governed by statute in Malaysia. And that is another way in which you can actually try and initiate a claim for payment disputes against your non-paying party. Finally, you have mediation. It's another way in which parties can resolve their disputes, but this is something that is usually between the parties where they negotiate and try and see whether they can arrive at a middle ground to settle the dispute. So to answer your question, Azman, all disputes do not need to be brought to civil courts. There are other means and methods to actually resolve them. Thank you.
Okay, here comes the second question. This question is from SY Lam. The question is, under CMGD clause, normally it's 27 months. If after the 27 months, still consider can claim damage under the time limitation.
Sorry,
I'll ask the question.
Yeah, I'm not sure I understand the question. Under CMGD clause, normally it's 27 months. If after the 27 months, still consider can claim damage under the time limitation. I'm not sure what you mean by your question, Lam, but your question is whether or not you're allowed to claim for, you can initiate a suit after 27 months. Yes, you would still be able to, because like I said, the damages, sorry, time limitation is 6 years usually from the time the cause of action accrued. So yes, you will be able to actually claim for damages under time limitation if there is, of course, a basis to do so. Thank you, Lam.
So the next question is, what is the purpose of letter of intent since it is going to have contract later?
Yes. Okay. So as I think this has been covered in the slides under my letter of intent slide. The purpose is essentially It is basically pre-planning. If construction contracts were entered into immediately at the construction stage, it would actually lead to absolute chaos. That is really the purpose. The letter of intent is essentially giving your contractor notice so that he can prepare for the contract, for commencement of the contract, and to sign the contract at a later date. It is essentially setting out the main terms that will all of it be reflected in the main contract, which is to be signed at a later date. So it is really just preempting the next step. It is, and also sometimes, like I have said, for financial reasons, for certain reasons where the project must be completed by a certain date, it may even be in the employer's own advantage to actually start works immediately upon letters of intent being signed. So it is just a process to actually make everything faster and smoother, so that by the time the contract has been signed, actually certain things may have already been started, have already been commenced at that stage. So yeah.
Okay. We saw people raise hands, so we'll allow them to talk if there's any questions. So the first one is Xiangli Teo. All right, I'll move on to Miss S.Y. Lam. You may talk now, you may ask your questions now.
Hello, Anji. Can you hear me?
Yes, I can.
Okay. Regarding this one, your last slide about the limitation period. Okay,
Yeah.
if let's say the meaning that after the CMGD, that means the certified of the make good of the defect. Okay, after the period that we still found what we call this some defects, are we able to request the contractor to come back and repair?
Okay, so it really depends on, you see, the certificate of making good defects essentially is a document to ascertain that the defects that you have highlighted to the contractor have been satisfactorily repaired by the contractor, which resulted in him receiving a document known as a certificate of making good defects, which means he has been certified to have made good all the defects which have been brought to his attention. Now, of course, if during that period or soon after that, you bring up the same defects to the contractor, it is likely that he will say, or in his defense, he will say that, look, these defects were something that were all rectified, for which I have actually received defects. So unless it is something that is new, then yes, you might be able to go after the contractor, depending on when you actually discovered the cause of action. But yes, ultimately the CMGD is quite an important document, and it will probably be something that the contractor will use in his defense. So you can only bring an action against the contractor if, for example, you can actually ascertain that those were defects which were not discovered at that point and therefore didn't fall under the CMGD certificate.
So meaning that we cannot claim with the same issue?
Yeah, that would be correct. Yeah. Unlikely to be able to claim on that same issue because so you have already issued the defect certificate. So that is the purpose. The CMGD is a very important document. It's basically telling the world at large, or rather the architect telling the world at large that, look, there were defects that were raised to the attention of the employer. to the attention of the contractor, and the contractor has satisfactorily met with all those defects. So yeah, you would want, if you want to claim against the contractor in such situations, limitation would still be applicable. Like I said, the 6-year period, but the chances of you succeeding in such a claim will really depend on the facts of your case, whether it's a new defect or whether it's a defect which has already been certified previously and so on.
Okay. Okay. Another scenario is if let's say after the what we call this, if under the contractor with after this completion of this CMGD periods, but the certificate is not signed, not issued. Is it that means that it is still considered as is not done, the defect?
This is a situation where the certificate is ready, but it's just
No,
not signed.
no. That means that after, okay, let's say we're talking about the CMGT period is 24 months, for example. Okay,
Yeah.
after the period, okay, 24 months of this CMGD, the defect liability period, but the certificate is not issued by the consultant or whatever. So is it considered it's not complete?
Yeah, I would consider that to be not complete, because the whole idea is when the contractor raises when your architect raises the list of defects, you have the contractor has a certain period of time to actually make good those defects. If he fails to do so, he won't get the certificate. If he successfully does so satisfactorily, then he will get the certificate. So to answer your question, it would be deemed that he has not satisfactorily completed the defects, or he's not made good all the defects which have been raised to him. That would be the significance of the absence of a certificate of making good defect.
Okay. Okay. Another scenario is okay. We're talking about this limitation period. That means that, in fact, if let's say the defect arise is not the same issue that we are listed in the what we call this the list of the defect, is it considered still can charge what we call this? We can request the contractor to repair it.
Yes, you will be able to, provided, of course, they say it's passed after 2 years, then they would be considered to be latent defects after the after the defect liability period. Say these defects are discovered much later on, and these defects are as a result of the contractor's failure for, say, workmanship, or contractors' failures for proper, it could be wall cracks, for example, or floor cracks, for example. Those kind of things will not occur during that period. So obviously the architect or the engineer could not have actually listed this down as the defects which need to be rectified. So under the certificate of making good defects, none of this appear. So yes, to answer your question, if the defect is discovered after CMGD, but it's a new defect 5 years down the road, which has to do with, for example, floor cracks or wall cracking, and you can actually ascertain that this is, in fact, not because of fair wear and tear, not because someone dropped something on the floor. It's all the floors in all the different units are cracked. Then it's likely that you will have a case against the contractor. So you have to bring your claim, like I said, within 3 years from the date you actually know of that particular defect. So usually that would be the situation, how the limitation applies.
Okay, so to confirm that, it means that the limitation period is start from the ending. What we call this, the ending of this CMGD.
It will be 6. So you're talking about limitation period for the. What's your question again? Sorry.
For the latent defects, that means that okay. Let's say I have signed the what we call this today, for example. I have signed the CMGD today, issue up. Yeah. Okay, but after this, okay, we have what we call this others find out the defects. That means that okay, we can claim against contractor.
Yes, correct.
Means that it's starting from the today or just from the beginning of the CMGD?
It will start from today, because this would be the cause of accrual.
That means that the date of the ending of the CMGD, the issue out, the issue out of the CMGD.
No, you're talking about the 6-year limitation period, or you're talking about the 3 years after discovery, because they are two separate.
I'm talking about the 6-year period.
The 6 years.
Okay, let's say today we issue out the certificate of making good. Okay. Yep. Okay, that means the limitation is start from today or from
No, from before. The limitation would start from actually when the complete project was completed.
That means from the CCC lah.
Correct. Yes, the CCC. So your 6 years already starts to run from there. So after 2 years, you get your CMGD certificate, and then after another 2 or 3 or 4 years, you may receive other types of latent defect claims. Then you would still fall under the 6-year period. But even if you don't fall under the 6-year period, in situations where the defect is discovered, say in the 9th year or 8th year, you would still be able to bring a claim 3 years after that, provided it is below 15 years. A bit complicated, but so there are 3 things you need to know here. First is you claim within 6 years from the date of accrual. If you don't claim within the first 6 years, which means in a situation where you have discovered the defect in the 7th, 8th, 9th, or 10th year, then you must bring your claim within 3 years from that particular period. So if you discovered it in the 8th year, then you want to bring your claim before the 11th year. Otherwise, you would be time barred and you will not be able to initiate the claim.
I see.
If you discover the claim in the 13th or 14th year, you can still actually bring a claim for latent defects against the contractor, provided, of course, there is a reasonable basis to do so. But if you discover it in the 13th or 14th year, then you won't have 3 years, because remember, 14 plus 3 is 17th year. 17 years is already past 15-year mark, so you are already time barred and limitation will apply. So if you discover it in your 14th year, technically you have very short time. Basically, you have less than a year to actually bring your claim. That's how.
Under your this last slide, there is the what we call this. There's a note that 6 years from the date of occurrence of such defects. That means that, okay, let's say, can I please correct me if I'm wrong. Okay, to me, to my perception is okay. Say today we are signing this CMGD. Okay, now after all the year, okay, let's say next day we found the defects. Only we found the defects. Okay, that means that we consider as from the date that we found the defects. That means that is tomorrow, for example. Okay, then it means from that 6 years onward.
Correct. Yes, correct. Yes, you will have 6 years from tomorrow. So tomorrow is 30th July 2021. You have till 30th July 2027 to bring your claim, to file your claim for latent defects.
I see. So it's still under the contractor's obligation to repair it lah.
Yeah, of course, provided it's subject to your facts lah. Is that if there is, the fault is attributed to the contractor, if you can show, for example, if you actually say the defect was 1 day late, is most likely your claim will be dismissed, because the court will be like, hey, you just issued a CMGD today, the very next day you are highlighting a defect. Clearly this is something that maybe, you all have overlooked on your part, so they may not actually grant it to you. But like I said, in situations where latent defects, something that cannot be discovered straight away, so obviously I issue you a CMGD, because at that point the defect hasn't occurred yet. The defect only occurred 5 years down the road. So in such situations, you are still protected. You're still able to actually commence a claim against the contractor for defects discovered later or after the CMGD. So the CMGD basically is just for that particular period of time to show that all the defects that I highlighted to you as at that particular date, you have made good, or you have actually satisfied the criteria to repair all those defects. But obviously, like I said, these defects are only very specific defects. There may be other types of defects which may be discovered at a later date, which you will be able to file a claim against the contractor. But ultimately, you will still have to show that this is something that the contractor has negligently or has failed to properly deal with in terms of workmanship or proper usage of materials and so on. For example, even if it's a floor crack or a wall crack, you can't just claim against the contractor, and it's not a sure win case. It's ultimately depending on the facts. If the contractor can come and say that he has built the walls and he has built the floors all according to proper regulations, he's got reports, expert reports coming in to confirm that it was all built according to proper regulations, according to proper industry standards, and that the floor cracks or the wall cracks are not the contractor's fault. It may be, for example, the user's fault. Then in such situations, the contractor will not be found liable. So the basis of determining whether or not you are liable for latent defects or not will be subject to the facts that come out in court.
Okay.
Yeah, you still have to prove it, because contractor will come and say, no, these defects are nothing to do with workmanship, nothing to do with me. This is just, rough usage or something like that. And they will have to prove it. Like I said, they will call the experts to court to actually show that this has been all done and complied with according to proper laws, proper industry standards, and whatever cracks that are occurring are not because of our fault. Then in such a case, they will not be liable for the latent defects. Of course, if it is their fault, very clear cut. Example, the landowner actually brings out their own report to show that, oh, they didn't do something with the flooring properly. As a result, there's water seeping. We have an expert report with that. The court will have to look at that, consider that, and probably find the contractor liable for latent defects.
Okay.
Yeah.
For another scenario, if let's say for mechanical parts, okay, we have an underground piping that we're having after the what we call this after let's say 5 years, then we only detect some leakage. Is it possible to claim under this?
Yeah, of course, it's possible. You're still within the limitation period, so you're still able to claim. But the question is, this is something you will need to ascertain, not through your lawyers, but through your experts, industry experts. You will need to actually question whether or not the crack happened because of defective workmanship or because of, non-usage of proper material, or is this something that cannot be claimed as latent defects? So whether or not it is latent defect or whether it's just not considered latent defect is something is called what we call a subjective test, meaning it is subject to how the courts interpret whether or not the defect is something that results from the fault of the contractor or it has got nothing to do with the contractor. If it has got nothing to do with the contractor, then your claim will probably fail.
Okay.
If it is,
Annie, thank you very much.
thanks.
So thank you, Mr. Lam, and thank you, Mr. Ankit, for answering the questions. So we have answered all of the questions that we received. So if there is no more questions, we'll move on to the feedback session. So please scan the QR code to give feedback on our session today. Mr. Ankit, you may show the QR code on the slide. Yes, this is the one. Thank you.
Thanks.
Dear participants, our next session is assessment session. So please scan this QR code for the questions and please submit your answer within 10 minutes. I believe that's all the time we have today. So this marks the end of our webinar. Thank you so much, Mr. Ankit, for the sharing. So thank you so much for joining us to all the attendees. So stay safe.
All right. Thank you, everyone. Bye-bye.